There's an issue coming up before the Senate this week which really goes to the heart of this institution and why it exists. The Constitution spelled out responsibilities for Congress and specific responsibilities when it came to this chamber. The 100 men and women who serve today, among other things, have a responsibility to advise and consent on nominations sent by the President for our consideration. The Constitution assigns the Senate the role of questioning these nominees, checking into their backgrounds, and then deciding whether to approve or disapprove their nominations. Over the past 2 years, we have seen many of the guardrails in this process disappear. For example, the Republican majority has stopped respecting blue slips on circuit court nominations. Blue slips, a Senate tradition, said that if a person is nominated to serve on circuit court, which is the second highest court of the land, that the senators from the state where that person would serve would decide thumbs up, thumbs down, whether the nomination goes forward, so-called blue slip. And for a number of years now, that has been the standard practice, the tradition of the United States Senate. The Republican majority has decided to stop the blue slip process when it comes to circuit court nominations. And they stopped moving bipartisan board and commission nominations in pairs. We used to say we have a more trusting relationship. If you get your Republican nominee, we get our Democratic nominee, let's do it together. That used to ensure that each party was equally represented on important agencies like the Securities and Exchange Commission, the National Labor Relations Board, and the Federal Deposit Insurance Corporation, to name a few. Now we have a rules change before us being proposed by the Republican side of the aisle to change again the rights of senators by limiting the debate time on nominations. This would further tilt the balance of power away from the Senate, away from Congress, and back towards 1600 Pennsylvania Avenue, the executive. It runs the risk, of course, of diminishing our constitutional responsibility. When it comes to executive branch nominations, this administration, has a different approach than we've seen before. We have a president who says he likes to have administration officials serve in an acting capacity. In January, President Trump said, and I quote, "I sort of like acting. It gives me more flexibility." Do you understand that? I like acting, the president said. Given that approach, perhaps it's no surprise that we've seen long delays in filling the leadership positions in important agencies, positions, ambassadorial posts. And we've seen the highest rates of turnover in these administration positions in modern time. People aren't placed in these positions, and if they are, they're looking for the exit way too soon. We've suffered from a lack of proper vetting and examination of persons' background before their nomination is approved. And we've seen a lack of bipartisan cooperation in moving board nominations where there's supposed to be equal numbers, Democrats and Republicans. Despite that, we are trying to do the work we're assigned by the Constitution to advise and consent. If the majority wants to move nominations faster, they can do what all administrations have done in the past and start working with the minority to negotiate packages of nominees. As long as I've been here, that's been done by leaders of both political parties. Fair bipartisan packages of executive nominees who have been well vetted. None of us want the embarrassment of putting a person in a position they're not qualified for or where there's any question of their ethical standards. That bipartisan work can lead to less debate time on the floor if we agree at the outset to work together. I'm particularly opposed to the Republican proposal before us to shorten the time for debate on President Trump's nominees to serve lifetime appointments on the federal district court. Imagine a lifetime appointment beyond this administration to serve on a court and make day-to-day decisions, some fundamental to the criminal justice system and some to the civil justice system, and to have a lifetime appointment. We understand what's really going on here. We understand when the other side says that we are obstructing them from confirming judges. the facts don't tell the same story. In fact, my Republican colleagues have been bragging for months about what Senator McConnell called the, quote, record number, close quote, of judges that the Senate has confirmed under this new President Trump. In President Trump's first 2 years in office, the Senate confirmed 85 Article III judges. During the first 2 years of President Obama, 62, 85 to 62. And the number of judges confirmed last Congress was nearly 4 times as many as the number confirmed under President Obama in the previous Congress. The pace of judicial nominations and confirmations has been extremely fast. So now, why are the Republicans pushing for a rules change to the Senate rules to make it even faster? It's not like the Senate has been busy with legislation here on the floor. Senator McConnell had a moment of candor last November after the election. He said, and I quote him here, "I think we'll have probably more time for nominations in the next Congress than we've had in this one. I don't think we'll have any trouble finding time to do nominations." Senator McConnell, McClatchy News, November 7th, 2018. Of course, Senator McConnell was frustrated that one senator put a blanket hold on judicial nominees at the end of last year. He expressed his frustration publicly. But that senator, incidentally, was not a Democrat. He was a Republican, Senator Flake of Arizona. It seems the real reason the Republicans want to change the rules now on district court nominations is so they can, in the words of Senator McConnell, plow right through, close quote, with confirming nominees whose records and views are incomplete or extreme. The reality is that all too often these judicial nominees just don't stand up to scrutiny. Already under President Trump, we've had 6 judicial nominations where the American Bar Association's peer review process found these nominees sent by President Trump to be, quote, not qualified, close quote. I might add, there were no unqualified nominees under President Obama. And last year, 2 nominees, Thomas Farr and Ryan Bounds, were withdrawn by the Republicans on the floor after the Senate had voted to move forward on their nominations. Disclosures about their backgrounds led members even on the Republican side of the aisle to say they wouldn't vote for them. They were withdrawn because that information came to light that caused these senators to change their minds about confirming them to lifetime appointments. That shows the importance of having some time, 30 hours currently, to debate these nominations and to make sure that a lifetime appointment is not going to someone who's unqualified or shouldn't be in that position. So who are the district court nominees that Senator McConnell wants to change the rules to move through more quickly? Let me tell you about a few of them. A Texas district court nominee, Michael Trincali, who called President Obama, and I quote, an un-American imposter, close quote, and described the Shelby County case when it came to voting rights as, quote, a victory, close quote. There's a Nebraska nominee, Brian Busher, who ran for elected office in 2014 and said, quote, I will focus on fighting Obamacare, close quote. Texas District Court nominee, Matthew Kaczmarek, who has repeatedly written in his personal capacity about his opposition to LGBTQ rights in the Obergefell case. Oklahoma District Court nominee Patrick Wyrick, a protege of the disgraced former EPA Administrator Scott Pruitt. He allowed an energy company to ghostwrite a letter from Pruitt's office when he was Oklahoma's Attorney General. These are just a few. There are many other Trump judicial nominees whose views are far outside the legal mainstream. And Republicans are determined with these rule changes to speed up the process so we don't ask questions. I have to say, it is stunning to listen to Republicans complain about obstruction of judicial nominees after watching the unprecedented Republican obstruction of nominees under President Obama. Under Senator McConnell, Republicans would not even give an appointment for an interview, let alone a hearing, to a well-qualified Supreme Court nominee, Merrick Garland. And in 2013, Republicans pledged they would filibuster anyone who President Obama nominated to the D.C. Circuit Court of Appeals, the second highest court in the land. No matter how qualified the nominee, they pledged to block him or her because President Obama was making the choice. And Republicans filibustered President Obama's judicial nominees 82 times in the first 5 years. Under all presidents before President Obama, there had been a total of 86 judicial filibusters combined with all presidents. President Obama in the first 5 years, 85. Throughout history leading up to that, 86. Now that the Republicans control the White House and the Senate, they want to rip up the rules, change the rules, traditions, and guardrails on the judicial nomination process on a regular basis. They are pushing through nominees who have not been found qualified by the American Bar Association. They are pushing through nominees over the objection of home state senators. They are pushing these nominees without making sure that they've seen their complete records. In the case of a North Carolina District Court nominee, Thomas Farr, his nomination was pulled when critical documents were finally disclosed while his nomination was pending on the floor of the Senate. It's no secret what's happening here. There's no emergency that justifies changing the Senate rules. Senator McConnell himself admitted that the Senate has plenty of time to consider nominees. This is all about avoiding close scrutiny for extreme and ideological nominees that Republicans want to pack onto the federal courts for lifetime appointments. I oppose the rules change. Let's do our job when it comes to conducting due diligence and provide informed advice and consent for lifetime appointments to the federal bench. It can be done. I will tell you that in the first 2 years of the Trump administration, we have been able, by and large, to work out bipartisan agreement on filling judicial vacancies in the state of Illinois, even at the circuit court level, to the point where Senator Duckworth and I gave blue slip approval to circuit court nominees based out of our own state, and to the point where we've reached a basic agreement when it comes to filling the district court vacancies to this point. It's been bipartisan all the way, and I believe we have found qualified people. It took some time and some bipartisan cooperation, but we did it. It can be done. We didn't ask to have the rules changed in the Senate. We used the existing rules to do our job under the Constitution. All the issues we care about are impacted by these nominees in my state and others. The Senate deserves to take the time to make sure we get this right. We should not be putting men and women into lifetime appointments without close scrutiny as required by our Constitution. Mr. President, I yield the floor.